In 2026, the United States repealed the rule that had formed the backbone of federal climate regulation for more than 15 years. With one decision, the legal foundation for many climate policies disappeared. But the story of that rule did not begin in Washington politics. It began with a lawsuit that few people expected to change anything. Yet that case would eventually reshape environmental law in the United States. And its consequences are still unfolding today. To understand why, we have to go back nearly 20 years. In the early 2000s, the United States had no federal regulations limiting carbon dioxide emissions from cars. At the time, climate change was already becoming a growing concern among scientists and policymakers. But the federal government argued that it did not have the authority to regulate greenhouse gases under existing environmental laws. The Environmental Protection Agency said the Clean Air Act was designed to control traditional pollutants like smog and soot. Carbon dioxide, they argued, was something different. Even if it contributed to climate change, the agency believed the law did not require them to regulate it. Several states strongly disagreed. Among them was Massachusetts. Like many coastal states, Massachusetts was increasingly concerned about rising sea levels and the long-term risks of climate change. State officials argued that greenhouse gas emissions from vehicles were contributing to a global problem that threatened their communities. And if the federal government refused to act, they believed the courts should step in. So Massachusetts and several other states filed a lawsuit against the Environmental Protection Agency. At first, the case did not attract much national attention. Many observers assumed it would quietly work its way through the courts and eventually disappear. But instead, it kept moving upward. Eventually, it reached the highest court in the United States. The case became known as Massachusetts versus the Environmental Protection Agency. At the center of the case was a deceptively simple question. Does the Clean Air Act allow the federal government to regulate carbon dioxide as a pollutant? The Environmental Protection Agency argued that it did not. They said regulating greenhouse gases would require balancing complex economic and political considerations. Those decisions, they argued, should be made by Congress, not by federal regulators. The states argued something very different. They pointed to the wording of the Clean Air Act itself. The law requires the EPA to regulate pollutants that may endanger public health or welfare. And according to the states, the scientific evidence already showed that greenhouse gases posed exactly that kind of threat. If the law required the government to regulate dangerous pollutants, they argued, then carbon dioxide should be treated the same way. In 2007, the Supreme Court finally issued its decision. The ruling was extremely close. By a vote of 5-4, the court sided with the states. The justices ruled that greenhouse gases do qualify as pollutants under the Clean Air Act. That single decision changed the legal landscape overnight. For the first time, the federal government clearly had the authority to regulate carbon dioxide emissions from vehicles. But the decision went even further. The court said the Environmental Protection Agency could not simply avoid the issue. Instead, the agency had to answer a specific scientific question. Do greenhouse gases endanger public health or welfare? If the answer was yes, then the EPA would be required to regulate them. That question set the stage for one of the most important environmental determinations in modern U.S. policy. 2 years later, the Environmental Protection Agency released its answer. In 2009, the agency issued what became known as the endangerment finding. After reviewing a vast body of scientific research, the EPA concluded that greenhouse gases do endanger public health and welfare. That single determination triggered a chain reaction. Once the finding existed, federal regulators were legally required to begin controlling greenhouse gas emissions under the Clean Air Act. Over the next decade, the endangerment finding became the legal backbone of U.S. climate regulation. Vehicle emission standards were strengthened. Power plant regulations were introduced. Methane rules were developed for the oil and gas industry. A scientific determination that many Americans had never heard of, quietly, became one of the most powerful regulatory tools in environmental policy. For nearly 15 years, it shaped how the United States approached climate change. But in 2026, that foundation was removed. The federal government repealed the endangerment finding. In doing so, It dismantled the regulatory framework that had grown out of the Supreme Court's decision nearly 2 decades earlier. Yet the legal story may not be finished, because the questions raised in that original lawsuit could soon return to the courts. States, industries, and environmental groups are already preparing for new legal battles over climate regulation. And once again, the outcome may depend on how the courts interpret a law written more than 50 years ago. The repeal of the endangerment finding may feel like a sudden change, but the fight over climate regulation in the United States has been building for decades. It began with a lawsuit. It reshaped environmental law, and the next chapter of that story may already be unfolding. But the story doesn't end there, because nearly 2 decades later, the rule created by that decision was repealed.